And then, Nick, we're going to go into the second question with yourself. And this is from an agent again, and on behalf of a tenant whose lease is in the name of a company from which obviously the tenant works. The tenant wishes to now terminate the lease before expiry in accordance with the terms of the lease agreement. The landlord argues that the CPA does not apply in this case as the lease is in a company's name as opposed to a natural person's name. He therefore claims that the tenant is liable to pay the rent until the end of the lease, which is at the end of August. Advice here, Nick?
Okay, perfect. So what we're dealing with here is Section 14 of the CPA, okay? Classic Section 14 deals with fixed term lease agreements, okay? And it's a complicated little provision, but I'm going to try to break it down as quickly as possible. So first thing to know is this deals only with fixed term agreements, okay? So I'm assuming from, and it's built into the question, this is during the fixed term of the lease agreement. If you've got an agreement which is running on a month-to-month basis, your fixed term is passed and it's like that, Section 14 absolutely doesn't apply to the circumstance. Now, what Section 14 does is it allows a consumer, in terms of an agreement, to cancel a fixed term agreement by giving 20 business days notice. That's the general thrust of the particular section. However, the section does not apply to transactions entered into between two juristic entities, regardless of their turnover or asset value. Okay, that's the first proviso of the particular section. And so what the writer has, or what the landlord in this particular question is trying to point out, is the tenant is a juristic entity and therefore can't rely on the provisions of Section 14 of the Consumer Protection Act. Now, the landlord might well be correct, but what we don't know in terms of this question is what entity is the landlord. Okay, the tenants, they've told us, is a company, and the person staying in property is obviously a natural person, but the lessee in terms of the agreement is a juristic entity. That's fine. The question then lies, well, what is the landlord? Is the landlord also a juristic entity? If so, then the landlord may be correct in their assertion that CPA cannot be relied upon. If the landlord is in fact not a juristic entity, as in it's their individual capacity that they're the landlord, Section 14 is in fact going to apply to this particular transaction, and they could use Section 14 to cancel the lease agreement early. Regardless, it doesn't matter the fact that the tenant is juristic entity. So that's the first thing when it comes to Section 14 of the CPA. The other part of this question is in terms of the person who's written in, they've said that the tenant wishes to terminate the lease before the expiry in accordance with the terms of the lease agreement. Okay, so it seems to me that they are not trying to cancel in terms of the CPA. So the landlord has gone, well, you can't cancel in terms of the Consumer Protection Act because the tenant is a juristic entity. Okay. But what it seems that the tenant is trying to do in the circumstances is not cancel in terms of Section 14 of the CPA, unless there's a provision that directly relates to the CPA. Okay, or let's put it this way: if there is another provision within the lease agreement that's agreed upon between the parties, so there's another form of cancellation that can occur in the agreement that has nothing to do with Section 14. This can be a common thing. For instance, there are a number of lease agreements that say in the event that there's a sale of the property, the landlord can give 2 months notice for the termination of the lease agreement. And a clause like that, okay, can be effective in terms of Sections 4.5c of the Consumer Protection Act. So as long as that clause doesn't prejudice any party or doesn't fall foul of good, it's not contra bonos mores in our law, okay? Those types of clauses in an agreement can be enforced. So I'm not 100% sure what clause they seek to rely on. I only get the impression that the tenant is seeking to rely on a particular provision of the lease agreement. What that provision says, we don't know at this point. Okay, but if there is a clause in the lease agreement that does allow the tenant to cancel for whatever reason, okay, it may well be that they can enforce that clause, and the landlords obviously going to the CPA to say, no, well, the CPA is not applicable in the circumstances, unless that clause specifically relies upon the CPA. there might be the ability for the tenant to cancel. If it is a clause in the lease agreement that says, in the event that the CPA is applicable to this, and the landlord saying, well, it doesn't, the landlord might be right in the circumstances. But unfortunately, we just don't have the content of what that particular clause says. So I will say to the writer, if you want more clarity and a definite answer in the circumstances, get in touch with one of our officers. We would be happy to look over the particular clause and give you a definitive answer. Unfortunately, for the purposes of this, we can only give you broad strokes, and I can give you, overriding principles of these of the legislation, and to sort of guide you on your way. But there is a definite answer. It just requires a little more looking into the agreements.
Sure. So yeah, thank you very much, Nick. Once again, an emphasis on the applicability of Section 14 of the CPA. And then that does bring us to the end of today's questions and answers, ladies and gentlemen. And we'll see everybody again next week, and have a good Easter weekend. Thank you, guys.
Thanks, guys.
Thanks, guys.